SJC-12491, Christopher Blackwell v. Commonwealth.
Mr. Blackwell, you can get settled, and when you get settled, you can begin. Take your time. I see you have only one arm you're working with, so take your time.
Good morning.
Good morning.
My name is Christopher Blackwell. I appear pro se on this matter.
Are there papers you're trying to get from your backpack, sir?
Yes.
Maybe Leandro, if you could help him, Mr. Rodriguez.
That's in accordance with Rule 22. Any written adverse statements.
Okay. Are there papers you need to get from your backpack, or do you have everything you need?
I have everything I need.
You do. Okay.
This is upon request. Adverse statements from the opposing party. Any new statements that I need to reply to. If the court's requesting to a response to those adverse statements, these are the statements or the reply. This is the reply.
That's your reply brief?
Yes, or if that's the issue. If we discussing that issue, because that's a little bit off the subject at hand, which is well, I'm arguing on judgment. I would like, or I request a judgment on law to remove from file this record, because I feel it was unconstitutional. So I don't know if the courts.
You should talk about whatever's in your reply, because according to the Commonwealth, they said that you were there for the suppression hearing and you had a chance, so you can respond to that.
In the actual July 15, 2011, in Exhibit 1 of the petition, it is not recorded on July 15, 2011, that a condition plea of foreclosing my rights as a defendant was mentioned or allowed. So that's violation of Rule 12. That if it's not recorded in the courts or mentioned in the courts, how would they, or how would the courts know that this actually occurred?
So can I ask you a question? If the court records say you were present at that motion to suppress, is that court record in error?
Yes,
Wrong?
well, that's what it's supposed to state, that I was present in that day of at that date, and it doesn't, because I wasn't there. I was actually back at the court. Back at the prison. Mm-hmm. So I wasn't present for that date. So
Now, is there a reason that you did not file a motion for new trial before the judge who tried your case?
Well, first, I was ignorant to the law, the legal system. Second, I wasn't present on that day. So how how can I seek remedy if I didn't know the action at hand, or that an action that to seek remedy of appeal? If I wasn't there, how would I know? And that's violation of Rule 18 and Article 11 of the Declaration of Rights. Because Rule 18, I never waived my right not to appear, so that's violation of that rule. But I would like to get into the issue where the suppression of evidence should have been actually concluded or determined by a motion or appeal, but it wasn't, because I wasn't, there to appeal, or appeal wasn't put in or submitted. So on the basis of two cases, Commonwealth versus Maynard, which the victim actually gave supporting or sufficient particulars in the descriptions of the defendant or the suspect, whichever one you prefer, the description of the vehicle and the actual description of the defendant or the suspect, and the first-hand observation of the firearm that he had in his possession, and he aimed at the victim, as opposed to Commonwealth versus King, where officers have no justifiable, no reasonable or justifiable means to justify the stop. They didn't have no articulable facts that supported their reason to warrant the stop. And I would like to reference collectively in comparison to this matter before you, with case law as well, 3 cases: Commonwealth versus Daniel Johnson, 49 Mass Appellate Court 273, Commonwealth versus Richard Sandberg, 477 Mass 393, Commonwealth versus Marta, 424 Mass 117, which the single justice mayor, I'm not sure her name, she actually submitted that order in her determination or conclusion to the denial of the motion that I wasn't present for. That argument is exigent circumstances or probable cause. Officers base their means to arrest off a simple hunch. The victim is stationary, or the alleged victim is stationary. No area or location was stated to determine proximity of an alleged gunshot. And officers did not have any knowledge of a firearm in the defendant's possession. So basically, officers subjectively executed their arrest and their search relying solely on subjective or description that was subjective. They did not know the victim. They didn't have reason to, I'm sorry. Basically, the time spent looking for the potential suspect's vehicle proved non-imminent of any threat possible. So basically, my argument is that this is not constitutional, this case throughout the process in its development. And basically, it was required of fruits of the poisonous tree. Basically, I said to the officers, that they didn't have a warrant. That's Fourth Amendment requirement. Basically, basically, I was coerced to make statements and do whatever it took because my rights wasn't respected.
Okay.
So,
Mr.
basically,
Blackwell, I'm afraid your time is up. Thank you, sir.
yes. Thank you.
Ms. Tilley.
Good morning, Your Honors. May it please the Court, Colby Tilley on behalf of the Commonwealth. I ask you today to affirm the single justice's denial of the defendant's 211-3 as it is for a number of reasons, one being that the 211-3 is not the proper avenue of appeal here, another being that the defendant pled guilty for closing his right to challenge the suppression issues, and the third being that the docket does reflect the defendant was present at the evidentiary hearings. There's 2 evidentiary hearing dates, May 11th, May 31st. The docket reflects the defendant was present on both dates, and the defendant has not demonstrated that a motion to suppress would have been successful, even if you were to evaluate all of the claims that he is making. If there are no questions, I
What do
will
you make of
rest.
the fact that he says now he was not present?
I'm sorry, Your Honor?
What do we make of the fact that he says he does not, he was not present, and you say that the records reflect that he was, and what do we do about that?
Well, I would first state, Your Honor, that it's not an argument that this court should consider at all, because it wasn't something that was, I'm trying to remember when he first raised the claim that he was not present in his 211-3. However, in his petition for rehearing, I believe there was no mention of it, as well as in the brief he filed with this court. I also believe there was no mention of his not being present at the hearing. Again, the docket reflects that the defendant was present. I would say the docket is prima facie evidence that he was in fact present. He was represented by counsel at that time. I'm sure there are further papers within the trial court. I believe he was in custody at the time, based on what the docket is saying, defendant brought into court, so there may be minimuses as well. But again, I don't think that's an issue that this court can decide. And I don't think it's actually before this court at this time.
Thank you.
Okay, thank you.
Thank you.